Non-disclosure agreements, which are often referred to as NDAs, are an important part of commercial life. If two companies want to enter into a relationship and trade or even merge, they'll almost inevitably start off by negotiating the terms of a non-disclosure agreement which protects their confidentiality. So it's quite important that companies and other organisations, and indeed individuals, are able to negotiate confidentiality and therefore use that as a stepping stone to carry out other commercial transactions. Recently, it has become apparent that NDAs are also being used in a different context in relation to when claims are brought for sexual harassment or other sexual misconduct, or indeed sexual discrimination. This has become apparent from the issues that have arisen around Miramax and Harvey Weinstein, and one or two other examples where it's become clear that the NDA has been used as a way of preventing someone talking about what has happened to them, and indeed telling others who may well be in the same position. It's become obvious in certain areas that there are particular features of the ways in which non-disclosure agreements have been used that do raise concerns. So, for example, the individual wasn't able to take independent legal advice, or there's an inequality of bargaining power between an individual and a large corporation, and also that terms were inserted into the non-disclosure agreement which were unenforceable, but obviously for an individual who would be concerned about challenging them, they wouldn't necessarily know that, and that would be a way of controlling their behaviour even if it wasn't legally possible to do so. So it's very easy to see that many have described NDAs as effectively a weapon that is used to control the behaviour of people who've made complaints around sexual harassment and other similar issues. Given what has happened, law firms will need to think very carefully about the ways in which they use NDAs to make sure they are using them and advising their clients on them for legitimate purposes. It's not difficult to see that if a law firm was to use an NDA in inappropriate circumstances, that they as a firm would be criticised, and that would bring the profession into disrepute, but also their client would be criticised, and it wouldn't really be in their client's best interest for them to advise them to do that. The challenge for law firms is that these are all new things for them to consider and to decide where the boundaries lie between a legitimate and entirely proper NDA and one where there are serious concerns and either they or their clients might be criticised. And certainly the legal profession needs to have a dialogue, I think, amongst itself and with others, such as the regulators, to decide where those boundaries lie, so we each have a clear idea as to when they can be used and when they should not be used.